We now further recognise the commitment for the sponsors as well and partners that have obviously sponsored the event, so thank you so much. Our panel 10 is in relation to governance, risk and compliance, which is obviously strengthening the governance reduced to legal risks in corporate litigation. It also shows how governance can help reduce exposure to legal risks. Moderating the panel is Ravindra Kumar, for partner of Gunnar Cook. Please welcome back to the stage. Our distinguished panellists are Rienke from partner Agarax in Netherlands. And Liman, managing solicitor at LIMO at Law in Ghana. And Mohammed Ibrahim Mohammed, senior manager corporate sales in DMCC. Over to you, Mr. Kumar. Thank you.
Thank you. The topic is GRC, governance, risk management of it, and compliance. We have a team of very experienced lawyers. I will introduce them one by one. It's Reneke Reizen. She is a Dutch lawyer, and she helps clients to the firefighting when they are in the most difficult situation. And we have Liman, who is a Supreme Court lawyer in the Republic of Ghana. He runs a law firm which works 24/7. And we have Mohammed, who is a senior manager with DMCC and advise people and assist them in setting a business in the UAE. I will leave all of them to add to these introductions. We'll give to Liman.
Thank you very much, and I'm most grateful to be part of this wonderful panel. My name again is Liman A. Mohammed. I'm managing solicitor for LIMO at Law. LIMO at Law is based in the Republic of Ghana, and we are into corporate, commercial, arbitration, and litigation. Thank you.
Yes, hello. My name is Reneke Reijnen. I've been a lawyer for about 20 years. I work in Amsterdam at a firm called Agarax. We work in sanctions, trade limitations, and also in corporate and commercial litigation. And myself, I am working in commercial litigation and corporate litigation, and have been doing so for a long time. And I also advise different lawyers on issues of private international law, second opinions and appeal advice, so I have a broad practice in commercial litigation.
Yeah, hi, hello. My name is Mohammed Ibrahim. I'm a senior manager of corporate sales. My main objective is to help companies to get registered, set up their business in Dubai, and today my main objective is to speak with a couple of lawyers. We have a dedicated programs called ISPs, International Service Providers, where we can help them to have direct access to DMCC to help the companies to set up their business.
Thank you, Mohammed. Do you want to tell us more about setting up in DMCC?
Yeah, sorry. So DMCC, it's basically a free zone, being established 22 years old. We are part of the government of Dubai, dedicated establishing Dubai global gateways and commodities for trade. We are a free zone regulator as well as trade facilitators. The DMCC falls into strong three main columns. Number one, when it comes to free zone registration, licensing, end-to-end services. But we are also property developers, where we develop different kinds of commercial towers to ensure the expansion happening in the same area of our existing members. And the most important part that we provide ecosystems, different kind of platforms when it comes to knowledge series, different kind of events, local and international events. And we focus into different kind of sectors when it comes to precious stones, precious metals, including blockchain, when it comes to crypto, AI, gaming industries. Today, DMCC, home of more than 25,000 members. That put us to be one of the largest free zone, fastest growing. 180 countries there represent themselves in DMCC, and 87 commercial and residential towers. We do have different kind of structures when it comes to DMCC Holding Co. We have a special purpose vehicle. We have family offices as well. The main objective, as I mentioned, is we create a dedicated program for lawyers who can be able to get connected with DMCC to help their clients to set up their business in Dubai in DMCC.
Thank you. So I'll ask, start the conversation. I'll ask Liman, what are the broad concepts of GRC which are relevant for corporate governance in today's world? If you can give some insight. Okay.
Thank you very much. Governance, risk, and compliance, as we are aware, is a strategic platform or blueprint that sort of tries or is implemented to align business goals or objectives with operational processes, procedures to reduce or manage risk and to ensure that there's effective compliance of applicable laws, regulations, and industry standards. When I talk of industry standards, I'm making reference to national standards, international standards, and standards that are peculiar to various industries. As we are all aware, organizations work within various industries. We have for-profit organizations and we have non-profit organizations. Beyond that, we have specific industries. For instance, if you come to the Republic of Ghana, we have the banking industry, we have insurance, we have manufacturing, we have small and medium enterprises. All of them have their regulations. So it's very important to be able to understand each of their regulations and ensure that there's compliance. I know it is important to understand the difference between governance, risk, and compliance, and that of ESG. Because yesterday we spoke extensively about ESG. ESG basically looks at sustainability, and then governance, risk, and compliance is looking at managing risk within the organization. And our focus is to look at how to manage risk within the establishment. And when we talk of governance, governance basically looks at policies that are implemented in the process of controlling and directing the institution. And for corporate establishments within my country, we have what we call the organs of the company, because we all know that companies are not natural persons, they are artificial persons. So they act through what we call organs. We have the shareholders in annual general meeting, we have board of directors, we have management, and these organs can also delegate people to act. So our focus will be looking at the role of directors in terms of ensuring that there is compliance to ensure that the risk that is associated with the industry is mitigated. And why is this important? It's important because when you go into an establishment, there are different departments. You have finance, you have legal, you have technical, you have operation, depending on the setup of the organization. And most organizations, they have what we call C-level. That's the chief operating officer, chief human resource officer, chief finance officer, and they all see themselves to be powerful persons within the organization. So sometimes it's very difficult to be able to align to ensure that you mitigate the risk. So the GRC is to ensure that there's a strategic alignment of all these functional departments or units within the establishment to ensure that the risk that is associated with the industry that you find yourself. So for instance, if you are in banking space, there are certain regulations that you are supposed to comply with nationally and internationally, so that you'll be able to put the mechanism in place so that all the departments are aligned. Why is it important to ensure this? It's important to ensure this because it makes decision-making very effective and very fast, because we are in a fast-moving environment and very competitive environment that requires that you should be very agile and effective in your decision-making. Some organizations, what they do is that when a decision is to be made, it's made by, let's say, operations department, it goes to finance. Finance will also do their business case 3-4 days, and then it moves to technical, before a decision is making. But once you are aligned and you have a platform that aligns all the functional activities, then it makes it very easier for you to be able to take decisions. It also helps in optimal IT investment. We are in a technological world that requires that you have a system in place to monitor all the regulatory requirements in terms of timelines, in terms of renewals of licenses and all those stuff. Once you have it online and it's a common platform, let's say an enterprise resource management tool that aligns the organization from end to end, it helps in reducing costs instead of having silo softwares or enterprise softwares that will achieve that. So there are a lot of advantages when it comes to ensuring that we have the GRC platform in place, because it allows that the entire organizational processes are integrated and are holistic, and it helps with decision making, enhances productivity, it reduces legal and then reputational damages to the organization. I think that I will try and answer that. My colleagues will also.
I'll ask you from the Dutch perspective, what's your views on GRC with respect to Dutch companies, and what the senior manager and board should look into governance side to minimize the risk of any officer or director's liability claims?
Thank you, Ravina. I think, as Liman already mentioned, governance is a framework of structures that is in place within a company to address risks, to have good decision making, and to inform properly about what have you done. It's important to keep that in mind when looking at directors and supervisors' liability, because governance is actually what directors and supervisors are responsible for, but what they are also liable for if they mess up. So in the Netherlands we have a joint responsibility of the board for strategy, financial decisions, risk, and for the general course of affairs, as we call it. And this joint responsibility becomes a joint liability when one of the directors is seriously to blame for mismanagement. So this raises the question, how do we delegate tasks? You know, the C-level, we have the CFO, we have the CEO, we have a lot of Cs doing their business, and the tasks are delegated, but the board is jointly responsible and liable for serious mismanagement. So in the Netherlands, delegation is not a problem, it's very common indeed. However, information must flow within the organization, and everybody must be aware of what's going on. This joint liability can be escaped from by a director if he can say, you know, I have seen what was happening, I've done everything I could to turn the tide, but I didn't manage. So what's really important in order to show that you have good governance is to have a paper trail of what you've done. Because if it's a joint responsibility and a joint liability, this means that if the damage is 100 million euros and one of the directors has caused serious mismanagement and is liable, all of you will be liable unless you can show what you have done to avoid this damage. So in the Netherlands we have internal liability, but also, and this is probably familiar to all of you, external liability vis-à-vis creditors and third parties whom the director has caused to suffer losses. So for instance, let them lend money while knowing that the company would not be able to pay back and would not be able to recover damages for that party. This is also where the supervisory board sometimes comes in. They have to, they're not involved in the day-to-day business of the company, but they have to supervise and they have to be informed and they have to make sure that information flows and that the board of directors takes good decisions and weighs the risks and is compliant. And in the Netherlands we have this example of the World Online case in 2000. This was an IPO where the company had one director, Mrs. Brink, and it made a prospectus, and the prospectus was, very enthusiastic. Everybody was going to make big money. The only thing that was not disclosed but was known by the supervisory board was that Ms. Brink had sold a large part of her shares just before the IPO and that the company wasn't so profitable at all. In this case, ultimately the Supreme Court ruled that the supervisory board, knowing, because they have the same responsibility and liability of the board, they knew what was going on, they didn't warn the public, and that they were liable for the losses. So I think, to round it up, in the Netherlands, governance is all about decision making, addressing risks, being aware of the financial position of the company. And if you want to strengthen your governance to minimize risks of being liable as a director for damages of, of internal damages or those of creditors, then you have to make a good paper trail. You don't tick the boxes. You don't say, yes, we have a supervisory board, yes, we have a compliance protocol, but you have to do it. Governance is all about behavior, about writing down what you do, analyzing the situation, and making sure that everybody, also the shareholders, are informed properly.
Thank you so much. So documentation of processes and actions are absolutely crucial. So I'll go to Mohammed from Middle East, and from GRC perspective, what will you advise businesses who are looking to Middle East, specifically Dubai, to set up business, what they should keep in mind?
Thank you, Ravindra. Well, I would say that legal structure and ownership rights, that's what number one is the most important part, is you need to understand how Dubai works. In Dubai, there is set up in the mainland, there is a free zone, there is an offshore, all of these that can give you access to 100% ownership. But the thing is, behind the legality frameworks and the complicity of the license selection sectors, that will play an important role. Number two, when it comes to board composition and local requirements, there is always a KYC for the appointed directors. In DMCC, we do due diligence, compliance for our existing employees and existing members. But the thing is, behind it, that you need to understand there is a certain type of requirements when it comes to selected sectors such as financial services or healthcare that you go for. The number three is you need to know that transparency and reporting at a yearly basis. You need to submit that a yearly financial certificate that comes from each company, reflect all the invoices that you have done between you and your customers. And we need to understand the UAE labor law, how it works, and how that will be able to behave in terms of the companies they set up their business.
Thank you, Mohammed. Liman, what do you think, what factors and challenges which the corporate leaders must take into account while they are setting up their GRC processes and implementation and blueprints in the organization? Can you share some thoughts?
Okay. Thank you very much. I think it's critical when you are considering implementing GRC to look at certain core principles. One is to ensure that there's transparency in whatever process that you are going to implement. You should also ensure that there is participation of all stakeholders, because stakeholders play a key role. And it's from these key stakeholders that the potential risk is likely to emanate from. So if your GRC doesn't take into consideration of the various stakeholders, you are likely to have a gap. You are likely to be exposed one way or the other. Your GRC should also be very responsive to the market, because if you are in the profit-making environment, that is a very competitive market. For instance, banking, telecommunication, and the likes are very competitive. So sometimes you are tempted to take certain decisions in reaction to the market. And if you don't have a solid system in place, it's likely to affect you. So you need to take that into consideration. The rule of law is also very important because of the compliance bit. You have to ensure that there's comprehensive data on all regulations, applicable laws, industry, based on the industry that you find yourself, so that at least if you have to rely on that system, you are sure that the potential risk will be made available to you. I think that is very key. These are very important and fundamental matters that ought to be taken into consideration. Thank you.
Thank you. Renika, we discussed that it's very crucial to record and document the processes. What do you think about internal investigation and whistleblower complaints? Should we deal with, and how does it impact the exposure to litigation on with the shareholders and stakeholders in the company?
Yes, thank you. Yeah, I think whistleblowers are a fascinating part of doing business, because in the Netherlands we have a law that is there to protect whistleblowers, so that if something is going on within a company, you have to be able and you have to be safe to voice your concerns and to say, you know, something is going on, either internally, like with the board of directors, or just with some employee who is running his own business competing with the company or whatever. And there's two layers to this problem, because if there is a whistleblower and he tells you what's going on, he can either signal something that can be fixed, but he can also signal something that can be fixed, and when the board doesn't fix it, it can explode and become bigger than anybody could have imagined. Because what happens, for instance, if there is a corruption case going on, some employee is corrupt and well, he is taking money from people who want to get assignments from the company, and somebody tells the board and says, you know, this has been going on, I've seen him driving in his big car. Well, actually he has 3 of those big cars, and you know, his wage is about 70,000 euros per year, so that's a bit strange, isn't it? I think something is going on, and I always hear him talking with this one agent. The board can do 2 things, and we see this happen in practice. The one thing is, take it seriously, listen to what's going on, start up an investigation, and see how they can deal with this issue in a good way that shows that the governance is in order. And that they are compliant with corruption rules that may be in place. For instance, if there is a UK or an American mother company, the corruption rules are quite strict. If you don't investigate and you don't act, you are a corrupt company and you can be in serious trouble. But what we also see happening, and that's more problematic, is that the board says, yeah, I've heard you, you know, I'm busy, go back to your workplace, we'll look into this, and don't you worry about it anymore, this is off your chest, we'll fix it. And then nothing happens. And then the whistleblower thinks, okay, so this is not a safe environment. Sometimes there's even retaliation. Hey, you're talking about one of the members of the board of directors. You're not being taken seriously, and the whistleblower thinks this is not a safe environment. You know what I'm going to do? I'm going to go to the media or to the authorities, or at least external parties that can have a big influence on, well, the future of the company actually. If that happens, the board can still make two choices. The one choice is, okay, let's comply and let's make sure that we fix this and be open and transparent and inform the shareholders, especially when it's a listed company, provide as much information as possible. Or they can make that same bad choice and say, you know what, let's pull it under the carpet, nobody's going to talk about it, nobody's going to know, we're just going to deny it.
Third option, call Renike.
Third option, call me and I'll advise you to do the right thing. But what happens then, it has already been a governance issue because something is really wrong within a company that is going to retaliate whistleblowers, that is going to put it under the carpet. I don't know if that's an international saying, but that's how we say it in the Netherlands. But whenever you decide as a board to not inform your shareholders, not inform the supervisory board, and to be quiet about it, there's going to be investors that say, you've misled us. These annual accounts, they show a good and healthy company, but you have this big corruption issue going on, and we don't know how this is going to end. And I think this is also what happened in it's not a corruption case, and it's not similar to what I've been saying, but in the Philips sleep apnea case, the problem was actually that they had faulty equipment for people who suffer from sleep apnea. So they stopped breathing during the night, and they had this machine that they could breathe through in order to sleep safely. But this machine was faulty, and they were breathing, I don't know how to say this, but it was not good for your lungs, what they were breathing in. That problem could have been fixed quite easily. But Philips decided to remain quiet about it for a little bit too long. And now the investors say, you haven't been honest. We've been investing in a healthy company, and now we know that you are very sick. So I think where information doesn't flow the way it should, small problems can become big governance issues that can seriously harm the reputation and the liability position of the board and the company.
Thank you. This panel has got a very wide territorial jurisdiction covering from Europe, Africa, and Middle East. So I'll ask Mohammed to tell us that what are the broad and most significant challenges which companies, while looking to set up in Dubai, face, or they should be aware of, or they should consider.
Thank you. I would say fragmented regulatory landscape, that is one of the most important elements that you need to consider. Dubai operates under UAE law, but we have different kind of free zones such as DMCC or DIFC that have their own rules and regulation. However, that's in line with the UAE law. That's number one. Number two, you talk about entity of the setup and the framework structure of that business. Labor law, understanding labor law, and Emiratization program. So if you are going to set up in the business in Dubai by force in the mainland, you have to go with the UAE labor law, which have Emiratization program that you need to apply to be aware of. The other way around, you talk about data protection, cyber security structure that comes under these type of business setups. So there is a lot of information that you need to be aware of before you decide to go to Dubai. But that mainly comes for the companies to set up, or owner of the companies. That's why the consultants, the law firms that does exist, where they can be able to ease the process for the customers to understand the process, how it works, what they need, what sort of requirements. I believe these are one of the most strong elements for you to consider, or the client must consider to come to Dubai. The most important part as well as to socialize with existing members, to network after your setup. Each company that's set up in DMCC or in the environment that required to open a bank account, so you need to make sure that the compliance goes the same compliance of the banks to understand the objective of this business or the setup requirements.
Thank you, Mohammed. Renike, the litigation or legal risks for the companies, how they should see it, like a legal issue, or they should see it as a corporate governance issue?
Well, I think you can. I think there's something to say for both. I think a lot of companies see the risk of litigation as a legal issue that should be addressed once and when it arises. And that can be a strategy. And I think there's a lot of companies that never get into litigation, that will not have big disputes that cannot be settled, and that think, we're not going to think about that, we're just going to do business. But also, if you decide, there's always the risk that somebody is going to start litigation against our company. I mean, you cannot know what other companies or people will do. You can anticipate on this, and if you anticipate, you're one step ahead once litigation occurs. For instance, what you can do is in contracts, the choice of law and choice of forum clauses are mostly like on the bottom of the last page. It's something you have to deal with. We're not going to look into it. It's a commercial thing. So if we are going to do business and I have to give away the choice of law and the choice of forum clause in order to get better pricing or whatever, we're going to do that. But if you want to anticipate litigation and if you want to have good governance, you want to be sure that you can adhere to the set of rules that you are adopting into your contract if you're going to do business internationally. So if you are contracting with a party that is in Brazil or in Morocco or wherever, and you are going to choose for the laws of Morocco or of Brazil, you have to be sure what is demanded of you if you want to do business there. And if you're going to court or arbitration, whatever, you want to know where you have to go and how this works and what is expected of you. So I think if you can anticipate litigation risks before you even enter into a transaction, this can seriously benefit the company and also the chances of success once litigation occurs. And then when it occurs, I think it's really important for a company to act quickly, to be informed about what's going on, set up investigations whenever necessary, just act. What we often see is that companies think, oh no, there's this dispute, we haven't been paid in 6 months, it's probably going to take a long while after this before we get paid, let's just do nothing. And they freeze. And once they freeze, the problem becomes bigger and bigger. So I really think it's good whenever you contract, but also just in your company, when you're trying to have a good governance, you want to anticipate that litigation can occur, you want to have good decision making, and you want to have minutes of everything that has happened, and of every dissenting opinion within your supervisory board or your board of directors, in order to be able to show what you have done to prevent this risk from exploding.
You want to add something?
Yes. To add to what Renike has said, we had the opportunity in Ghana to determine this matter. The Bank of Ghana is mandated by an act of parliament, and every bank in Ghana is supposed to be registered as a company. And the laws in Ghana requires that a company must have minimum of 2 directors. But Bank of Ghana, as part of their corporate governance policy, have set the number of directors between 5 and 13. And I think that Bank of Ghana is also doing this with international standards, Basel Committee and the rest, to ensure that there's good governance. So there was a company that wasn't happy with this and then took it to the Supreme Court, that if the Companies Act says the minimum number of directors is 2, why will the Bank of Ghana raise it from 5 to 13? And the Supreme Court was very clear that it's a specialized area, and the Act allows the Bank of Ghana, depending on the economic environment and the regulatory environment, to come out with policy, corporate governance policies to ensure that the place is strengthened. Thank you.
Wonderful. I'll just add to it. It's good, Lalia. Reneke initially said that it's a good practice to document the processes and actions. What do you think will the corporate should adopt, like a best practice, best practices for corporate compliance and governance to implement and to minimize and mitigate risk to the companies?
Thank you very much. I think what is important is to ensure that there is an effective organizational structure and a management system that will be able to ensure that there's end-to-end implementation of GRC. I believe that from the conversation we have all had, the responsibility is on directors and most of the jurisdictions. Anytime there is any liability arising from the act of the company, because the company is an artificial being and acts through the directors, it's the directors that are liable. So it's very important within our jurisdiction. Like I said, the Company Act has a minimum of 2 directors, but from best practice, it is better to have many directors, because if you have many directors, the understanding is that you are likely not to be able to influence them. And once they know that there's a joint liability, there are going to be checks on one another. And that is why the Bank of Ghana in Ghana has decided to move the minimum from 2 to 5, and then a maximum of 13. I think that is very important. And we also spoke about the fact that we need to have a team in place to be able to ensure that we have the systems in place. So for instance, most boards in Ghana have what we call committees. They have subcommittees. One of the subcommittees is on risk, and they are supposed to advise the board on the risk strategy that is supposed to be adopted. And they work with management to ensure that the risk strategy is developed. Every institution is recommended that they should have a team for risk management. So most of the banks in Ghana have what we call the chief risk officer, with a team in place to ensure that there's regular internal control and internal monitoring. Because once you have a platform in place, it means that there must be somebody who will be monitoring to ensure that the various risk factors are clearly defined. And with the risk team, they'll be able to define, because with risk management, it's very important to be able to determine your appetite for risk. There are some that are risk averse, there are some that are risk takers, there are some that are risk neutral. It is the work of the risk management team within the organization to be able to determine your risk tolerance, based on which you can now do the various assessment, and then come out with the strategies that you need to adopt. And there are various strategies in terms of risk avoidance, protection, transfer, and all that. So once you have a team in place that are well organized, they will be able to determine your risk appetite and then the various risk strategies that are involved. Then they can advise the business to be able to comply. It is also very important to ensure that whatever your strategic goals are aligned with your business operations vis-a-vis your risk appetite and then your risk strategy. So these, I believe, are very important to ensure that you remain competitive.
Renika, you want to add anything?
Yes, maybe I can add a little bit to it. I think what's also important is that if, as a board of directors, you take governance seriously, that you invite new board members to be vocal about possible concerns. Because what we often see in, for instance, family businesses, is that this family has had this business for a very long time, and then it's always father, son and daughter being in the board of directors, and then something happens and they decide that an outside person, somebody who's not a member of the family, should come in and should be on the board of directors.
As an independent director.
As an independent director, but that person has to deal with a lot of family dynamics, you know, about how important this business is, and we've been building it for such a long time, and you know, this is my father and he's done all of this. If you want to be on that board of directors, I think a very important thing is to ask yourself, can I do this? Can I ask the difficult questions? Do I dare to interfere in this family business that is, and I'm not trying to be impolite, but that is so full of itself and of its success? Do I dare to interfere? If you don't go on that board. I think that's I don't know if anybody here is on a board of directors, but if there's something you should advise your clients, I think when this question comes up, that would be your advice.
Yeah.
Okay. To add to that, I think what is also critical is that with some of the boards, there are a number of terms that you can actually run. After that period, there's a cool-off period that you cannot come back to the board, or you can't go to a similar institution, just to ensure that at least you don't have. And some of the industries also don't allow more than one relative to be on the same board. So, for instance, if you are a member, you can have your immediate family to also be on the board. So these are mechanisms that can be put in place to ensure that at least you have a lot of independent, and there's also a quota on the number of independent directors that can be on the board. That is non-executive, you know, and there are certain positions that cannot be part of the board. So these are mechanisms that can be put in place to ensure that.
That's very insightful, actually. I think there should also be some chartered directors, like trained directors who are absolutely independent and have been trained to be unaffected by the influential board and should be able to discussion. I think I will leave it now for the audience to ask any questions if they have. Yes.
Thanks to the panelists for this very interesting conference. This might be a bit of a silly question, but something that came to my mind now that Lyman was speaking about risk management team within a company to sort of act as a counterbalance and to sort of find an equilibrium. I was wondering if the panelists have any thoughts or any experience of what happens when these sort of mechanisms to find a counterbalance and an equilibrium might be compromised, might be corrupt, or might be otherwise try to be silenced or influenced in their decision making.
So he's saying that if the board who want to raise question is been silenced, so what should be done? Correct?
Oh, is that the question?
Yeah, I mean, well, the risk management team or whatever other countermeasure team within a company, what happens when there's some influence within that team? So it sort of neutralizes or can result counterproductive toward the objective of having this entity within a company, I think.
Okay, thank you very much. So, as we indicated, and Renika also indicated, the liability on the company is jointly and severally on the directors. And for our laws, if there's any breach of our company laws, it's directors that are liable. So for instance, if the sanction is imprisonment, all the directors will be put in prison. Yes, except that you are able to demonstrate that your fiduciary duty, because your duty to the company is fiduciary, you need to act in good faith to the company. You need to be diligent in your duty to the company. So what will happen is that they will go in there, lift the veil to see whether you were diligent, whether you exercised your fiduciary duty with diligence. If you did, then you will be excused. But if you are not, the directors will be responsible. And that is why, in fact, and I have seen a situation where a lot of directors have resigned because of this. It's your duty. If you feel that something is going on wrongly, and you don't want to blow the whistle, you need to resign. But you see, if you resign and that act has been perpetrated, your resignation will not exculpate you, because once the conduct once the act or the crime was perpetrated before your resignation, you will still be liable. So it's always the best to blow the whistle, let the regulator, if it's a regulated environment, know that these are the challenges and you are not part of it. And I believe that you'll be fine.
Yeah,
That's within my jurisdiction.
I think I'll add that, as Renika said, document it.
Yes.
Yeah,
Yeah.
that's what I wanted to add.
Yeah.
If there is no other way to solve this issue than by leaving the board and resign, then you have to write down, I have warned all of you, somebody in here is corrupt, this is going on, I see that my advice is not taken to heart, I'm resigning because I've done everything that I could to avoid the damage that you are causing. And that's quite a difficult letter to write, but as Liman said, it's the only way to disculpate yourself, because if you don't do this and you just sit there and you're quiet and you think, you know, I'm not able to stand up to this person, then you're going in with them.
Because otherwise you don't be the director, as she said.
So I just remembered a typical example that happened in Ghana. In Ghana, we had challenges with a lot of the banks that were not properly managed. Their corporate governance was poorly managed. That is how come Ghana introduced the national corporate guidelines. And there was this bank that took liquidity support to support the bank to reach its minimum capital requirement. But when the director took that liquidity support, he decided to set up another bank. Whilst the bank that was existing was falling below the minimum capital requirement. So there was this, my client, that's my former employer, you know, that he went to him. He's a very renowned business person, that I want to set up a bank and I want to make you the chairman of the board. And he is in the insurance space. So he told him that, look, I'm running insurance. My long-term goal is to set up a bank, but not at the moment. And he said, oh, don't worry. I have investors coming from abroad. They will bring their investment. I'll make you the board chairman. I'll give you 10% of the shares. He agreed, joined. He took the liquidity support. So when Bank of Ghana closed the existing bank and then closed the new bank that they put the liquidity support into, now Bank of Ghana went after the board of directors, including this innocent person that was brought in. So fortunately, I was part of the team that represented him. And you know, with criminal matters, the court will always look at the mens rea, that is the intention behind the act. So after the court went through, the court realized that this particular person, though he was a director, he did not have any criminal intention. He was only just convinced to be part of it. and he was used as a witness. As we speak now, he's a free person walking, and then the former director is currently in jail. Thank you.
So the key word is again, be courageous. If you are asked to do something which you think is not right, then don't do it, and document it. Depending on the size of the organization, I will also say that they should have some compliance officer or general counsel who should be, there should be one designation responsible for the compliance, independent of the shareholders or directors, uninfluenced by them. And I think, yeah, that's it.
Yes.
Anything else from anyone? Oh.
Hi, thank you very much. It was a wonderful discussion. I think I would just wanted to give you the perspective from the Indian, legal perspective. For all the listed companies, which are the listed, and you must be very aware of it. You need to have a 50% of the board as independent directors. That is number one. And you can't be the promoter's family, or the executive director can't be the member of audit committee also. And also the other thing is that when you become an independent director, you need to qualify certain tests. You have no monetary relationship, etc. So that is always there. But initially what was happening was in India also, when there was a legal case, people were issuing summons or notices to all the directors of the company, and even the regulator was issuing the board was issuing the notices to all the directors. So many of the independent directors have started resigning from the companies. Then in the new law, what they have done is, the amendment was that in case as an independent director, you have noted your dissent in the board of directors minutes. So example, you are not agreeing to one of the proposal in the board, you're sitting in the board, you straight away can't say no, you say, people are not agreeing to you. That the only thing you have to do is that your dissent should be recorded in the minutes of the meeting. If it is there, then you have an immunity from that offense. Otherwise, you will be treated as a part of that, and connivance with that offense.
That's very helpful. Yes.
Can I ask you, do you have to say why you dissent, or do you only have to note that you dissent?
No, you have to only note the dissent, that I don't agree. If you can give the reason, that's fine. Even if you say that I don't agree with this proposal, that means you are at least not part of that, the offense or non-compliance, at least. So tomorrow in the trial proceeding or something, court may even ask, or the regulator may even ask that why did you give dissent? You may have to give the answer for that. That's a separate issue. But initially in the minutes books, if you only record your dissent, that's enough for you, right?
I wanted to also add that most often in Ghana, the decisions of the board are in the form of resolutions. And in the resolutions, you definitely have to state the position of each of the directors. I wanted to also share, there's this model that I came across by Julian Unwin on 5S for corporate governance: stewardship, support, stretch, strategy, and scrutiny. In fact, the stretch touches on the question that he asks, where the board is required to stretch the employees to ensure that they are very bold in whatever they do to ensure that there's corporate compliance.
Thank you. If there's any other question, otherwise we'll thank the panel. All right, thank you so much for the insightful discussion. Anything? Yes, thank you so much.
Thank you so much.
Good.